which you so nobly serve comes from destruction, disorder, and chaos. Now take this empty glass. Here it is, peaceful, serene, boring. But if it is destroyed, look at all these little things. So busy now. Notice how each one is useful. What a lovely ballet ensues, so full of form and color. Now, think about all those people that created them. Technicians, engineers, hundreds of people who will be able to feed their children tonight so those children can grow up big and strong and have little teeny children of their own and so on and so forth, thus adding to the great chain of life.
Water, fruit.
You see, Father, by creating a little destruction,
A cherry.
I'm in fact encouraging life. In reality, you and I are in the same business. Cheers.
You're a monster, Zorg.
I know.
Okay, that is known, and we'll start the next lecture in a course of principles of criminal law and the general part of criminal law as a whole. So the idea which will be the theme of our discussion of nowadays, it's very simple from one point of view and very complicated from the another. You know that sometimes one of the famous French writers, soul makers named Victor Hugo said that an invasion of armies can be resisted, but not an idea whose time has come. Well, the idea is that sometimes we can't understand the difference between special characteristics of crime. Sometimes we use these special characteristics trying to get a new information or trying to get a new ideology. Sometimes it is very interesting because of nowadays. Well, for example, when we're trying to understand what just exists, the whole world of today, we'll try to bridge any information about the current time, the detentions, the limitation of human rights abuses, and so on and so forth. Well, it's simple from one point of view. From the second point of view, the ideas which shared among nations is very specific. Very specific as the history, as specific as the elements of misunderstanding of what is doing during specific ages. Sometimes it is very complicated to, the lawyers to be involved in. Yesterday I had a discussion with one of my colleagues, and I just asked a question. What do you think about the possibilities of the scales between characteristics of law obedience, and the characteristics of human rights? From one point of view, it's very simple. Yes, human rights is the basis, and where's the tail? From the other point of view, law obedience in the period of detention and so on and so forth, it's very, very specific theme. Mostly the specific theme which I want to say of nowadays is connected with the idea of stages of crime. Stages of crime. Why do I say that it is a very specific element? Why do today I wear the T-shirt with the Real Madrid sign? Just I'm not a just a very. I'm gonna try to Yes. Okay, sometimes this is very hard to do and to understand what we have to do with the stages of crime of nowadays, because from one point of view, it's very simple. We have 3 articles in the Criminal Code of Ukraine here, or basic criminal codes of whole world. Well, the people said, what are the characteristics of committing a crime? What are the stages of committing a crime from one point of view? From the second point of view, it is very hard to do and very hard to understand because, well, because of the concept of the intention, because of the concept of voluntarity of preparation of criminal act, and we'll discuss it by nowadays. Well, if you want to be more sophisticated in these cases, just I'd like to show you one of these books. That is the book of Doctor of Law, Professor, the Dean of Law Faculty of University, Lviv National University, named after Franco. So Mr. Bourdian is the author of this monograph with this connected with the stages of intention of crime. One of the best authors of nowadays in criminal law, Vladimir Tuliakov. He is the head of the Department of Criminal Law in Kharkiv National University, National Legal University, named after Viacheslav. So Vladimir Tuliakov, he is one of the authors of this brilliant book, which is connected with the soul crimes and soul ideas. If you are familiar with the Russian literature, there is, for example, a very, very brilliant work which is made by Professor Kozlov, and it is connected with the same ideas. And if you want to, you'll share all information regarding it. The candidate dissertation of one of guys who was prepared this book, usually also connected with the ideas of stages of crime. You're welcome to read it now. Okay, just next. Well, the last book I want to share with you, well, you know that sometimes, well, before war, in Russia, they were prepared an encyclopedia of criminal law. And this encyclopedia of criminal law consists of very, very many specific ideas of what criminal law is, the philosophy of criminal law, and so on and so forth. That's why if you find these works, that is, for example, chapter 5, which is connected to the idea of stages of crime, you're welcome to work with. And we begin from the beginning. We know that, as usual, when we say about the sources of criminal law and sources of crime, criminal legislation, pardon me, we're saying about the ideas from one point of view, the doctrine, from the second point of view, the legislation, from the third point, the judicial practice, from the fourth court, precedent practice, the decision on constitutional court, the international treaties which are the part of national legislation, and so on and so forth. One of them is legal doctrine. Sometimes it is not very popular, for example, to say about the legal doctrine in Ukrainian situation, yes, or somewhere else at the Soviet or post-Soviet spaces as a whole. But when we're saying and when we're giving any information about the ideas of what criminal law or criminal legal doctrine is, for English-speaking lawyers or for common law countries, one of the main interested in the situation, and not only the situation, but the ideas, is the characteristics of works of famous English lawyer named Blackstone. So Blackstone's rules or Blackstone's ideas on torts, Blackstone's ideas on criminal law as a whole, Blackstone's ideas on civil law are very popular among English-speaking lawyers. And that's why, for example, I'll try to give you a very short glimpse of Blackstone's idea what we have to do. Well, there's problems with internet connection of nowadays. Pardon me if somebody is could not be involved because the number of participants is 40, and sometimes it is hard to put on the new one. So Blackstone said that crime is an act committed or omitted in violation of public law, either forbidding or commanding it. So the idea, crime is an act. Crime is an act which was committed or omitted so this act which was done by commission or omission. In violation of public law, either forbidding or commanding it. So it means that
Вячеслав Алексеевич, извините, пожалуйста, а можете впустить девочку в конференцию? Она не может зайти.
Вот это меня радует, каким образом я могу кого-то впустить в конференцию, если у меня полное того.
Все, спасибо большое. Она написала, что она уже попала сюда.
Okay, thank you very much. But sometimes you want to speak here. Well, just try to understand that that it is recorded. That's why this part of lecture I have to throw out. That's why it is not useful to myself or well, useful to all to speak during the this case of lecture. Pardon me. So. A person that commits a crime, voluntary or after preparation, makes specific, specific acts of behavioral activity, and these specific acts of behavioral activity are well connected, and they involves of 4 main steps. Well, try to reach these steps by a very, very, very short, not idea, but a very short cartoon. I hope that you like cartoons as a whole. So let's start. Okay, that is a lecture on criminal law, not the different kinds of cartoons, but this cartoon is very interesting for the idea which I want to share with you during this lecture, that it is connected with the stages of crime. You know, we have a crocodile, yes, we have a soccer ball, we have an elephant, we have a mouse, and we have a position when the crocodile began to start his activity. Okay, then after that, it's very hard to get some people in the conference, because I don't know why, but today, well, maybe it is connected with the characteristics of our internet or something else, I don't know. Okay, so the idea is that the person commits the crime voluntary or after preparation. The preparation is for 4 steps. One of them is intention. The second one is connected with the preparation. The third is attempt, and the end is the sole crime or accomplished crime, committed crime as a whole. The first position, well, it is not involved in this movie, what it is involved in our life. The first position is mostly more sophisticated and more ununderstandable in criminal law nowadays. What I have to say, the idea is that intention to commit, so the mental state, the first state, intention to commit as usual, is not evolved in criminal code, just intent. What does it mean? It means motives. It means motivation, and it needs to be motivated in some position. There is a very big difference in this characteristics. Try to understand. Motives, that's an inner part of our psychology which give us the possibility to urge to something, yes, to possess something, to create something, or so on and so forth. For example, when we're saying about criminal motives or motives in criminal law, we're saying that these are the motives with the urge to survive. For example, when we have to understand some societal motives for our life, these are the motives for the urge to eat. And we're saying about the vital motives of our life and our behavior. These are the motives or the urge to possess. And we're saying about greed and other social motives of our social life, or the urge to create, and we are creating something. That's the criminals have the urge to create. Yes, especially when we're saying, for example, about crimes on intellectual property or crimes which are connected with the ideas, not only the ideas, with the situation with the computer. Computer crimes as a whole, the crimes, well, in this field. Just try to understand when we are using, for example, a huge amount of people who are trying to, well, get to one or other program as a whole. We know that, for example, that at New York now, that New York schools, during this period of detention, the use of this program, Zoom program, is forbidden because of some malware practicing during this period of time. Because some hackers are used to the situation to get to our lectures. If some hackers want to get to our lecture, they are welcome. But from the other point of view, try to understand that some people realized well, other positions during doing that. Motives, the urge to conquer, it's very, very specific motive of our life. You know that jealousy, for example, one of the kinds of the urge to conquer and to possess, and so on and so forth. During Soviet era, well, very many criminologists said that motives are antisocial. I can't say about that. I can't understand it as a whole, because as for me, every motive is neutral, socially neutral. But sometimes they should be analyzed from the case, from the understanding of social or governmental values. You know, there is a difference between governmental values, between social values, between personal values, and we have to harmonize all it in criminal law. That is the fact. From the other point of view, when we're saying that hooligan motives are antisocial, and hooliganism that is antisocial, we took, nobody understands what we have to do. Or we say that the theft is a greedy motive. Yes, the theft has a greedy motive, but what if the motive has a business? If I possess some specific property from another people, or if I possess land, what are the main motives? What are the difference with this motive? Social labeling. So that's why social labeling is used, but it is used in a very complicated manner, in a very complicated situation. That's why when we're saying about stages of crime, and especially when we're saying about the intention to commit a crime, one have to understand that the intention to commit a crime is not an element of crime which is prohibited as a whole. Intention to commit a crime is a crime which is prohibited in a very specific ways when they are put into the criminal code as a whole. For example, when we're saying about bribery, yes, and you know that offer of bribe is criminalized, and agreement to get or agreement to offering of bribe is criminalized too. That's why, for example, if I agree to take something illegal, yes, I can do anything. But I say, well, guys, okay, if some people would give to me some money or something else, well, maybe it would be good or not. But that is awfully now, due to anti-corruptive measures at our state, that is a crime. From another point of view, we have a very specific definitions of such a crimes. For example, when we're saying about threat to manslaughter, yes, so threat to manslaughter is criminalized too, especially when we're saying about threat to homicide of president or a statesperson, of international person, and so on and so forth. There are different motives of this deed. There's different characteristics of it, but the idea is that if a person is committing a crime and beginning is urged, sometimes the state said that the urge to commit a crime should be criminalized too, but in a very, very specific manner, depending on international relationships and international treaties, like in anti-corruption legalization, or depending on gravity of crime, like in manslaughters and so on and so forth. You understand that? Motives, motivation, and to be motivated. What is the difference? Well, just remember your minor ages. First time you has broken your grandma's vases or something else, or you take a sweets or doing something. What did you tell to your relatives, to parents, when you motivated your activity? You say, well, guys, it is not bad. Or you say something that will give you a positive characteristic. As usual, nobody has motivated himself as a criminal. When we're discussing with a criminal or professional criminals their activities, they say, well, we are thieves. We possess or stole property from another people, but we can't kill people. When we are arguing the characteristics of criminal activity with violent criminals, they said, well, guys, yes, sometimes we possess lives, but we can't possess property. You understand the difference in the position? The position which characterizes not only professional thieves, but characterizes everybody. Motive versus motivation. Motivation, that is the process of formatting motive. The process of formatting motive, that is a psychological process, which means some specific stages, and during your involving in characteristics, or mostly in the course of criminology, you'll be mostly we'll try to understand what motivation is. It's very hard because the mechanism of criminal behavior depends on specific stages, depends on specific elements of our lives. The mechanism of behavior as a whole is connected with a very, very specific moments of people's motivation. Sometimes we can't understand that. Sometimes we can't analyze it, because it is very hard to, for example, to analyze hidden motives, which are not understandable at the first time. We know, for example, about the crimes of substitution, when one people who were abused by somebody just found another victim and killed her. There's the fact. We have so many substitutive motives, especially now, for example, when we are saying about the situation of frustration. What do you know what frustration means? This frustration is the psychological stage of our mind or of our psychological state when our urges are blocked. And our urges are blocked by something which we can't survive or overturn it somewhere. And that's why we are finding another way of making our life better in the same situation. You know, there was a very specific not a novel, but a very specific short story by La Fontaine, and after that we use it by Krylov. Well, it's Russia by Krylov, yeah. So there is a story named The Fox and the Grapes. The fox came to the grapes and just looked at them and found that these grapes are very, very high. She can't attain them. And she said that grapes are green. That is one but typical kind of reaction for the frustration. From the other point of view, the frustrated mind of nowadays, for example, when people are hard by this misuse of law, but people are hard by the specific elements of our life, should be connected with some kinds of activity. And the criminologist said that we naturally will have a very specific period of time, not only in Ukraine, but a very specific period of time, which will be connected with this specific positions of some people to overturn the cases of frustration. You know that in these cases we are based upon on the growth of suicides at families, or the growth of homicide activity, family violence, and so on and so forth. That is hard to do, but one can't understand that in this situation we should make another position, and we should to clarify as lawyers what they have to do with them. For example, when we're saying about intent, yes, and the intentional characteristic to commit a crime, we have to understand this position, that motivation, motives as a whole, psychological elements are used to criminalize behavior only in situation when the state has decided to do that, not as a whole. One can't prosecute your thoughts. Well, from our point of view, it's very interesting to the state, especially, you know that in China they used a specific mechanism or clarifying your social activity. The same mechanism are trying, for example, now to get on in Austria for, for one of the other elements is to understand of your, not social, but activity as a whole, because to your smartphones, the Austrian government is used them for, calculate all of the citizens of Austria and their deed and their activity during the period of this unlawful detention. Why do I say that it is unlawful detention? Because, it's that is a fact. It's very interesting fact to understand, especially to a lawyer. And I just asked our members of parliament last day on this situation. But if you look through, the Council of Europe documents, or you look through European Court of Human Rights memos under the Article 15, you know that up to this day, only 9 countries in Europe withdraw from Article 15, or withdraw from European Convention. And these are, for example, Albania, or North Macedonia, or well, what else? For example, Latvia, Lithuania, and so on and so forth. So the small states, very small states with not huge amount of monies or economies. Well, it's a very interesting prognosis regarding this fact, because some people said that the small states are doing that for using additional forces while the, well, mass activities will begin. I don't know whether it's right or not, but the situation is very uncomplicated of nowadays, and that's why to say that your thoughts are the elements of criminalizing it, it is not right. As usual, we're saying about two main elements of stages of main elements of preparation to crime. So that is attempt and preparation. Preparation, that's a very simple from one point of view. Yes, everything in criminal law is very simple if you're trying to reach and understand what is the essence of this position. So preparation is a procurement of means, tools, adaptation of these means and tools to willful creation or committing a crime. So procurement of means, procurement of tools, adaptation of means and tools for willful creation of means of crime or commission of crime as a whole. That's all. So we have to arrange necessary resources. We have to prepare these resources for execution of intentional criminal act. We have to prepare it in some way for making a corpus delicti as a whole. Just remember this movie, the crocodile, take, the soccer ball, then begin to start to run with it. After that, the crocodile take the mouse. And using this mouse, it began to put a ball into into the roles. But from the other point of view, what we say, what we have seen, that it is hard to do. Well, I can't, yes, another girl just came to our conference. So, the crocodile just prepared everything. The crocodile began to make an attempt, but he can't do that. So that is why we have two elements of crime in all of the deeds of the crocodile. Preparing the means, I mean to prepare a mouse, and I mean to prepare possession of, I mean to prepare to possession of a soccer ball. And after that, we just look at the situation when this girl can't do anything with the ending of a game, because it was one of the elements of crime was not ended. So preparation. To arrange necessary resources for the execution of intentional criminal act as two main positions, which can be understandable during our working in. What did I mean? At first, I have to say about that preparation to petty offenses is not punishable under criminal law of Ukraine. As usual, it is not punishable as a whole, as the whole world. We look, for example, for European legislation. At most European countries, people said, and criminal codes said anything about preparation. By the way, yes, sometimes it is constructed in criminal code, or it is written in criminal codes, that preparation is prosecuted only in situation when this activity is written on the special part of criminal code. So preparation to crime is prosecuted only in the case when it is predicted. So constitutable elements of preparation of crime, yes, there are the elements of the crime as a whole. As usual, preparation of crime is not active as a whole. Well, the one more discussable question regarding the preparation of crime is connected with the characteristics of commission and omission. Yes, commission and omission, what is the difference in the case? From one point of view, some people said that there was a great discussion in legal literature the 70s of the last century, when some people said that preparation to with acts of omission is not useful as a whole. One of the greatest leaders and one of the greatest minds in criminal legal world of the 60s, the head of the Department of Criminal Law of Moscow University, named after Lomonosov, Miss Kuznetsova, and her PhD was said and argued that preparation to omission is not useful with Soviet criminal law, but this position was not very popular. Because, as usual, we're seeing that sometimes the omission and active omission, when I have to act, but I can't do that, we should be prepared to. If I have the proper responsibility on doing that, and I can't do that because I prepare for not doing that, I should be, my behavior should be criminalized. That's why, for example, in our legislation, when criminal code of Ukraine, the legislator will put a special article under which procurement of means for an act of omission is always criminalized. So, attempt, the beginning of execution. So I possess what I possess. I possess, for example, a knife. Yes, I have a knife. Just this knife, I put it in my pocket, and then I'm walking down the streets with this knife for the aim of robbing somebody. While I possess this knife, that is an element of what? That is an element of preparation. When then I find a victim somewhere in the black streets, because the streets are empty because of the current time, and I open the knife and say some words connecting life for the knife. Yes, what we should do in this situation, that is the attempt crime. Yes, but from the other point of view, that is not attempted. My example, because that is a robbery. The threat of knife in this situation should be qualified as the accomplishment as a whole. From the other point of view, if I can't only prepare for this operation, that would be a preparation, and attempt should be criminalized or should be punished in the situation. Well, for example, I can't do anything in this situation. I just prepare to rob people or to make some operation in it. But from another point of view, I can't do anything in this situation because of the police officer who is located somewhere near, or because of pedestrians and so on and so forth. You understand that? I understand it too. So a person is guilty in an attempt to commit a crime if she doesn't act, but an execution was impossible. That is the idea. I am doing everything from the point of myself. The crocodile is doing everything. He put a mouse to an elephant. Yes, an elephant hides, and the crocodile just began to shoot a ball, but the head part makes it impossible for him. You understand the idea? Yes. This is why towards the beginning of execution of crime twice committed, it was not executed because of impossible understanding of doing the whole corpus delicti. The last element of crime, because we have well, the limits of our time, the last element of crime is the soul crime. The soul crime as a stage of a crime means that the person just committed a whole corpus delicti of the whole crime, and this completion means that we are making, well, the person makes everything intentionally for understanding what he or she is doing during this period of time, and this activity is prohibited by criminal code as a whole. What kinds of soul crimes existed in our legislation of nowadays? At first, this is the simple soul crimes. That means that I, by myself, make, well, all the elements of corpus delicti, or 4 or 7 elements, depending on characteristics of our culture. But for example, I make everything which is connected with object matter, subject matter of crime, object and subject, and these elements constitute a crime in special part of criminal code. So continuous crime. Continuous crime means that a criminal commits a criminal offense which is connected with an act which continues in time, or which connected with the so-called criminal state. What does it mean? For example, abusive elements. Yes, I can't pay elements for my children, for the wife which I'm in the divorce, and that's why I have to be criminally prosecuted. Or, for example, escape from a jail. I am escaping from a jail, and during this period of time, since the beginning of escape till the catching of myself, there was a continuous period of time where the crime would be executed. Understand that? Yes. Or illegal possession of arms. I take a knife and I put this knife to my pocket and walk down by the street. If this knife is qualified as well, a specific weapon, I should be prosecuted. That is the understandable. But the crime begins since I take this knife and put it into my pocket. And, well, it ends when the police, for some reasons, will just find this knife into my pocket. This whole. Okay, complicated crime, continuous soul crime, continuous crime, complicated crime. What does it mean, complicated crime in our criminal law? The complicated crime means that a girl, a criminal, just committed a crime with a specific psychological mechanism. Mostly our specialists said that complicated crime is oriented not only on subject or matter and object matter of crime, but on psychological mechanism of doing that. What does it mean? That is a specific intention of doing crime. For example, I am working somewhere at a plant, and every day I take some elements of my production, and then I just stole them every day during a very huge amount of time. During the Soviet era, you know that, for example, it was very interesting position or very interesting notion of some people. We call it catchers. It's Russian, we call it nesuny. So the catchers, they were the guys or girls who every day was trying to get some goods from the plant where they work, put it out, and after that sell it, and so on and so forth. Well, that is a very specific element of doing or working with, but it is working in the connecting of complicated crime. You know, for example, when we're saying about complicated crime and analysis of complicated crimes in English, because in England it is a traditional to use a complicated crime as a sole crime as a whole. From the other points of view, one say that, for example, for our situation in our world, that that's a mechanism where to do it with the sole intention, or 2, 3, 4, 5, 7, 8, or something else. These they are united by a sole intention to commit a crime. They united for the sole intention for the getting the criminal results, and that's why that is the difference between. There's a psychological difference between the sole crime as a whole and the complicated crime. Some people say about the specific crimes we have always at our legislation, they call them, well, constructed crimes. The constructed crimes means that these are the crimes with the double forms of fault, double guiltiness crimes, or these are the crimes which are connected with the two specific elements, every element of which in the object side of matter is constituted a specific crime. For example, abuse of powers which are connected with the violence against people. Abuse of power, one point. Violence to people, the another point. You know, for example, we have the same situation of abuses 2 or 3 days ago when some police officers here in this region were trying to well, seize a guy who sells coffee at the seashore. I don't know what I have to do with the qualification of this position, but that is a typical elements of abuse, not of abuse, but of misuse of power in this element. That is not an abuse up to the decision of the court. Try to understand it. I can't give a qualification depending on the characteristics of legal state of nowadays. Understand it. Robbery, the same element of constructive crime, because it is connected with the threat of violence and possession of property. The threat of violence which aims to possess a property. That's a characteristic of robbery which is used by our legislation. That's why, for example, when we're saying about robbery or other constructed crimes, we're saying that is a sole crime. Yes, it is constructed from 2 crimes, but it's a sole unified crime. You understand that? And the last question of this conference of nowadays is connected with the voluntary refusal crime. Well, sometimes people didn't want to do something. Yes, you are preparing everything, but after that you say, well, guys, there will be a criminal responsibility on it, and can't do that. Well, it was very simple. And I know that the fear of criminal responsibility is not working so properly as we want to say about that. But the voluntary refusal means the termination of the participation in criminal activity due to characteristic of proper psychology or proper motivation. So that is the termination of action which was aimed to commit a crime. What does it mean? The refusal is not subject unless its act is not commits contain full elements of crime. Try to understand it. If you refuse to commit a crime, you are not a subject of criminal responsibility. Well, that's a very interesting as a whole. The last position is very interesting as a whole. You know that if you want to be charged, yes, with criminal law, you have to complete all 4 elements of crime. Yes, to be subject. Yes, to have an object, to have subject matter guiltiness, or you have to make an object matter as a whole. Yes. Due to that, due to the characteristics of corpus delicti, It is very interesting that this, due to these stages of crime, due to preparation of crime, for example, or attempt, in this, these elements are not, well, constitute the subject. They are not constitute the corpus delicti. So they are not constituting elements of crime as a whole. And that is why the new position in the criminal legal doctrine of Ukraine or some post-Soviet countries as well is based on the idea that possession of means, that preparation of crimes or attempt of crime, these are the special corpus delictis with the absence of object matter or incompleteness of object matter of crime. These are the special objects of corpus delicti, and that is why the responsibility in this situation is one of the elements under which we are constructing our criminal policy of nowadays. That is the case, that is the idea. The next position in the specific elements of corpus delicti will be analyzed in the next lecture. We'll try to speak about mafia, yes. Mafia, organized crime, conspiracy, and all the elements which are connected with these processes, the elements of crime, when we have the difference between organizers' activity and the executors will be analyzed at the next time. So thank you very much for coming and joining. Hope we'll see you at the next lecture. And by the way, try to use your resources to get our web seminar. I mean, the seminar which are connected with my YouTube channel, which is done especially for you. Thank you very much for coming. See you.
Zog here.
Am I disturbing you?
No. Just. Where are you?
Not far now.
Good.
How are the stones?
Fine. Just fine. I'll have the 4 stones that you asked for any time now, but it wasn't easy. My costs have tripled.
Money is of no importance. I want the stones.
You.